Real property is our last topic for the course. Throughout history, property has continued to be the indicator of family wealth and social position. The protection of people's rights to their property became and remains one of the most important rights. So, real property, as I indicated, a sign of wealth and social position. But let's see how these rules play out modern society. So let's start with this legal problem that we'll talk about throughout this discussion. So we have Rosa and we have Sam, they're neighbors. They're living in rural northern California. On her property, Rosa plants grapes and begins to operate a vineyard and winery. A few years later, Sam, who operates a small gravel pit on his land, wants to enlarge the business. The expanded excavation will throw more dust into the air, and large trucks and other equipment will come and go from Sam's property more often than it has in the past. The increased dust and vibrations will harm Rosa's operation. So the question is going to be, and keep in your mind, can Sam use his property as he sees fit, regardless of the effect on his neighbor's property / business? These guys are our neighbors, and when you own property, you can do what you want with it. So let's talk about real property and the various ways in which real property can be owned. And we're also going to examine how these ownership rights in real property are transferred from one person to another and what effects they may or may not have. So nature of real property. It includes land and things attached to the land in a relatively permanent manner. Remember our fixtures? So that is our definition of real property. It includes land and things attached to the land in a relatively permanent manner, which means they're not movable. So a building that's erect on a parcel of land, both the land and the building are real property. If a barn is on it, a shed is on it, if these things cannot be easily movable and are relatively permanent in nature, they're part of real property. It also consists of plants and trees, meaning the natural and cultivated real property. But if you are growing a garden or you're involved in a timber business and you're extracting those things, then as you remember from personal property, those things can become personal property. But if they are relatively natural and cultivated and part of the property, then they are going to be considered real property. And that also means anything that's under the surface of the land and the air above. So, and of course the fixtures. So these things that we're going to talk about: land, the subsurface rights, water on land and adjacent to land, the airspace, and the fixtures. And with regards to the fixtures, we've talked about that when we talked about mortgages, we talked about that when we talked about personal property. And basically fixtures are personal property that become permanent when they're attached and therefore considered real property. So let's talk about land. What is the land? So the land is includes the soil on the surface of the earth and the natural and artificial structures that are attached to the land. So it includes all of the waters that's contained on and under the surface, and much, but not necessarily all, of the airspace above it. So the exterior boundaries of the land extend straight down to the center of the earth and straight up to the sky. If there are to be significant limits on air and subsurface rights, we have to indicate those things in a deed or other document that transfers property. So when we discuss these things in a little bit more detail here in a second, the land, soil, structure on the surface, everything below, everything above is what you own. Water, if you have a pond on your property or a lake and your property surrounds it, it's yours. Let's talk about the subsurface rights here. What I mean by the subsurface rights could be minerals, could be oils, could be gases, could be water of some sense, some flow of water. These things can be extremely valuable. As an example, there is an ongoing fight in the Adirondacks and lots of counties that are not in the Adirondacks, but it is primarily in the counties involving the Adirondacks: Franklin County, Clinton County, Essex County, St. Lawrence County, as far out as Jefferson County in parts, Lewis County. Is that there is this organization or outfit, business, whatever you want to call it, that is claiming to own the mineral rights in numerous, I should say, properties, state and private owned, throughout the Adirondacks, claiming they own these mineral rights, and hence they can come in and dig up the land to get them. So they send out these, I call them scam letters, but they shakedown letters. They send out these letters to property owners saying, we were granted rights in the minerals, pay us X amount of dollars, or we're going to come with a bulldozer and dig up your land. And of course, you get a letter like that, it freaks you out. So that has been ongoing. A couple years back, this group decided to take on the state of New York, who owns a lot of the land in the Adirondacks, and Lime Timber, which is a timber company that owns a lot of land in the Adirondacks that cuts down, trees for their business. And New York State and Lime Timber have made several arrangements with each other in rights and access to the land. And these mineral guys, why not? Lime Timber has money. New York State has money. Let's shake them down. So they've been in a long battle with regards to mineral rights. And I am personally affected by this because I have land in the Adirondacks. I've received one of these letters, and nowhere in my deed does it say that mineral rights are taken out. But I spent a good amount of money and a good amount of time to trace my deed all the way back to the 1800s, to where there was mineral rights extracted out in one exchange. So we go far enough back, I could see where that came out, but there is no evidence or anything that shows that this person who's sending everybody scam letters, how they then acquired it, because back in the 1800s, these mineral rights were given to a company that no longer exists and hasn't existed in hundreds of years. So anyway, kind of digressing there, but subsurface rights can be it can be valuable. And if you own property and land, it's yours. If you have minerals, oils, gases, water underneath. But like I just said in the example, the ownership of these things can be separated, and each owner has the same amount of rights to it. The problem is you need to get on the property and dig it up to get your minerals, which means you kind of affect the top owners, surface owners' right to their land. So you can't do that. You have to fix any damage. So it becomes a little sticky situation when you have two owners that have these separate rights. Things like gas and oil, I want to talk to you about this concept called captured. Technically you own, and the states differ on this issue, you own what's underneath your land. So if you want to dig a well and pump the water out, you are absolutely free to do that. It's called capture. And while on its face, you own the land, you own the airspace above. Anything below the subsurface, in some states, you own it. Whether you put a well up and dig it, or you do some sort of piping system and get the oils and gas out, it's yours. Nobody can come on and come and get it. Some states say, no, it's not yours until you take it out of the land. Hence the water, you put a well in, you pump out water. Both, in any of those situations, I can be your neighbor, and I can put a well in on my land. I can build a well on my land, and if the water runs in my direction and I pump it out, I am free to pump it out and quote unquote capture it. Same thing with gas and same thing with oil. What I can't do is come on your property and put a well in and pump water. But if the water flows underneath the land and can be captured, other people can claim ownership to it. Water. Let's talk about water. And this is not water that's on your property like a pond. This is water that borders property. Do you have rights to bodies of water that border your property? rivers, streams, waters that flow. You might share with other adjoining landowners, and there might be an owner across the other side. This is when we're bordering. And there's two types of ownership relative to that, and it's kind of divided in the country. In the eastern side, we have riparian rights. On the western side of this country, we have something called appropriation, the appropriation doctrine. So I'll give you kind of the New York version, which is the general eastern side with regards to riparian rights. What that means is you have rights that are created from the ownership of your land that's bordering the water course. So it includes part of the bed of the waterway or borders on public water course moving. There isn't anything, some people are confused with, why own 3 feet out to the surface? That gets a little sticky. So if I'm paddling my boat, my kayak down the river, and I'm on top of the surface of the water, but I may happen to be like 2 feet from your shoreline, you can't kick me out. Everybody has rights to be on the water surface. You can't say, oh, you're on my property, because I'm not. Everybody has rights to the top of the water space. So, riparian rights, you can use it. Your use is reasonable and must not unreasonably interfere with other riparian owners' rights. So if you're diverting the water in some way or altering the water course in some way, if it interferes with the use and enjoyment for somebody else who might be downstream or across the way, you can't do that. You can use the water, you can take as much as you want, you have a reasonable use of it, you just can't affect somebody else's use of that water. The appropriation doctrine, which seems a little odd for the West Coast, these doctrines are based on the riparian rights in the East Coast. We have plenty of water here. There's rarely ever a drought. But in the West, there's always water problems and drought problems. So they have this appropriation doctrine. And you would think they would limit the ability on using water, but no, it's a first come, first serve. If you're the first one to take the water, you can continue to take the water for your own benefit. A number of the western states still have this. Doesn't particularly seem right, but it's, the first in time use, first in time to use, the first in time to get. It doesn't matter what your neighbor, if it affects your neighbor or not. So then we have airspace. You own all the space above your property, airspace. There are some very limited restrictions. In the early airspace cases, this kind of involved things like, somebody shot a bullet across somebody else's land, does that constitute trespass? Or whether a telephone wire could run across the top of somebody's property. Nowadays, we're talking about airplanes and drones, right? Can an airplane fly over your private property? Yes, private or commercial. The key is it does not interfere with your use and enjoyment of your land. Like, that's the key in affecting somebody else's land, is whether or not it interferes with use and enjoyment of land. And I'm not going to go into the rules of FAA for the airlines. Common is above 500 feet, I believe. The planes fly above 500 feet, but then drones fly a lot lower than that. And every state has different rules relative to flying drones. Can your neighbor fly a drone over the top of into your yard and above into your airspace? They sure can. But there's certainly restrictions with regards to that. They can't go below 100 feet onto the private property without the owner's consent. They can't do it with intent to harass or annoy. Can't do it in a reckless manner, which it might create some risk of harm to the public. So, and it has to be within the restricted airspace that's given to drones. So that's the general rule relative to drones. So if your neighbor has a drone, they fly it over your property, they're certainly well to do that as long as they're not below 100 feet and they're not doing it to annoy or harass you in any way. I actually represented an individual who decided it would be a good idea to fly a drone over the wall of the Clinton Correctional Facility in Dannemora. For whatever reason, he thought that that would be a good idea. And when he did, like 20 guards came running out of the front door, and somebody was videotaping this. So he had a friend with him who was videotaping with him. I believe he wanted to really see what kind of reaction he would get. And what he got was a bunch of guards running out at him to take away his drone, to which there was some sort of altercation. He claimed he had a First Amendment right to do that. Yeah, that's not the case. And since that time, New York State actually last year passed the law that you cannot fly a civilian drone within 100 or within 1,000 feet of a correctional facility. So that's a big number, which I think is like the whole town of Dannemora. So I don't think you can fly drones in Dannemora as a result of that. But anyway, I digress again. Fixtures. Let's talk about fixtures. We've talked about them before. Personal property that becomes real property when reasonably permanent to the real property. So an item of personal property that is attached. How do we determine whether or not an item is a fixed, is an item that becomes a fixture? You have to ask yourself, what was the intent of the owners? Did the owner intend to permanently attach personal property to their real property? So for example, we have Julie and Mark. They're selling their home. They have a unique bird bath on the front of the yard. It was a family heirloom. When potential buyers come to visit the property, they note and they see that, oh, look, okay, there's a bird bath. Inside the house, buyers note that there's central air conditioning, there's window drapes, there's a washer and dryer, there's a detached garage and 3 rows of blueberry bushes along the side of the house. And I ask you, if Joan, a buyer, wants to make an offer to buy the real estate piece of property, but she wants all of these items included, will they be included? And if not, how could she get them included? So we have a bird bath, we have central air conditioning, we have window drapes, a washer and dryer, detached garage, and 3 rows of blueberries. So we have 6 things. So the question is, are these fixtures? Because if they're fixtures, they're going with the sale of the property, regardless to any outside agreement. So I think we can agree that central air conditioning is a fixed item that's now part of the real property. The detached garage is probably a permanent structure. It's just not attached to the garage where you can walk in. You have to park your car and walk out and then walk to the house. That's going to be a permanent fixture to the real property. And then let's see, what else do we have? We have the bird bath, we have the window drapes, we have the washer and dryer, and we have the 3 rows of blueberry bushes. What about those blueberry bushes? Those are probably permanent to the property, growing on the property as the blueberry bushes. The other items, the bird bath, the window drapes, and the washer and dryer, those are personal property. Those can be easily moved or removed from the real property. So if Joan wants those things, they have to be negotiated into the contract for the sale of real property. So now we move on to ownership interests. How do we own property? We have 3 types. We have present interests, future interests, and non-possessory interests, types of interests that we might have in property. Property ownership is viewed as a bundle of rights. I think I said that with regards to personal property as well. When you own something, you have a bundle of rights that comes along with it. You can use it, you can possess it, you can dispose of it in any way. And the term was, we hold that in fee simple. So we can't own property as this abstract concept, right? It exists because we have this legal system that recognizes that we have these rights. So let's look at each one of these interests here. So present interests. We have 3 different types of present interests. We have the big one, right? The fee simple and absolute. Sometimes for short we just call it a fee or a fee simple. But it's called a fee simple absolute. That contains the most ownership rights. It's an estate or interest in land with no time, disposition, or descendability limitations on it. It's the right to use land for whatever purposes the owner sees fit. So it's the highest estate in the law. Duration, like I said, potentially infinite. You can transfer it in any way you want, inter vivos, remember that, while we're living, or by intestate succession. That means without a will. It could just pass to who's ever next in line if you don't have a will, or by will, testate, meaning upon your death you have stated who your property will go to. So that's how people buy property, and they'll own it in fee simple absolute. Of course, as we know, in our modern society, might be subject to mortgages or some state laws like zoning or some environmental laws. If you live in the Adirondack Park, there's the Adirondack Park Agency and the rules that you have to live by. There might be some noise restrictions. We have those things in place because you cannot, while you own your right to your property, you can do whatever you want with your property. You cannot use your property in a manner that unreasonably interferes with others' right to use or enjoy their own property, because they have a right to use it any way they want. If everyone was using it that affected other people, then we'd have some problems, right? So let's talk about fee simple. Defeasible means capable, defeasible means capable of being terminated, and hence that's what our fee simple means. So we have something that is capable of being terminated. So not every transfer of real property creates this fee simple absolute. Some transfers can limit the interest or the estate. So an estate or an interest, I kind of use them I think the book uses estate. I like to use interest, so I use them together, defined. This is defined as an estate interest that can be taken away by the grantor on the occurrence or non-occurrence of a specified event. So the original owner retains a partial ownership interest. If a condition occurs, then the land reverts back to the owner or the heirs if the owner's not alive. So for example, Bob conveys to Alan an interest in his property that reads, quote, Bob conveys to Alan an interest in his property that reads to Alan as long as Alan uses it for church purposes. Okay, that's a valid conveyance. Bob dies 10 years later, and then let's say 25 years later, after the conveyance, Alan starts to use his land as a daycare. What result? Well, this is a fee simple defeasible. So despite the fact that Bob died, there still is this termination. A can only use the property as long as he uses it for church purposes. He's no longer using it for church purposes, so the land reverts back to Bob if he was living, but he's not living, so it will go to whoever was entitled to have the property as his heir. Then we have a life interest. We also call it a life estate. It's an interest in land that exists only for the duration of the life of some person. A conveyance of land to A so long as she shall live, or to B for his life. We've also seen conveyances as a life tenant. And that's what you call someone who has a life interest. So you call them a life tenant. And this is extremely common. What it means is, what it doesn't mean is that you're not like a tenant. When somebody rents property from somebody else, or somebody rents an apartment, there's a landlord, there's a tenant. The life tenant has the same rights as somebody who owns the property in fee simple absolute. The only difference is they only get to use it for their life, and then there's something that happens after. And I'm going to talk about the something after when we talk about future interests. But life estate, let's tell you a few more things about life estates, and then I'm going to give you another example. So a life estate can only be made by deed. The only way you can transfer this property interest is by deed. The life tenant can do whatever he or she wishes with the property. Except they cannot commit waste, okay? Meaning they can't destroy the property, they can't let it go, diminish the value, they have to keep it up. So they can use the property as if they had it in fee simple, i.e. those exclusive rights. They can sell it, but they can only sell what they have, which is the ability to be there for life. So if they sold it to somebody else, and once that life tenant dies, then it dies with somebody else too. They must maintain the property. Like I said, cannot diminish the value. They cannot misuse the property. So I have Julie, who is a life tenant of land. She can use the land to harvest her crops. If she had a mine and oil wells that were already on the land, she can continue to mine and oil. But she cannot further exploit the land by creating new wells or mines. So once she's past the life estate, if she was the one that passed the life estate, she can only use what's there. She can't diminish the property any further. This is common. We see this happen a lot with older folks who are trying to have their real property. Most of the time, real property is the only asset that people have that they will be able to pass to heirs or their children. So what they do when they get older is they create a life estate where they are life tenants until they pass away, and then the property reverts to whoever they have named in the deed that it passes to. And this prevents having to go to court to get a deed, put in your name, because it's an automatic exchange. And I'll talk about that a little bit more when I talk about future interests, which we're going to kind of switch to in a second. So our future interest. This is a holder of, this interest has rights, but the holder of this interest has the right to or the possibility of possession in the future, okay? While they may own the future interest right now, it's not available to them to use or possess. So if you see, in this instance, well, we have two types of these, and these rights can be bought and sold. We have two types, reversion or remainder. So X conveys to Y for life or to Y for 10 years, and once those things expire, Y dies or it's 10 years later, in that particular instance, the property reverts back to the one who transferred it. And X may be living, or it may go to X's heirs, but if the deed says this property is to Y for life or to Y for 10 years, then it's done. Remainder interest is a future interest in the third party, so you'll have the same thing. B conveys to Joe for life, then to Tom. So Joe gets to use the property or land for his life. Tom can't use it or possess it at that moment while Joe is there for life. But when Joe dies, then Tom can use it or possess it. What we see a lot of, and I was explaining, and I know the book goes a little bit more in depth in this particular topic, is that when we have, normally what we see is the people who own, or the person who owns the land in fee simple already, they retain or deed themselves the life tenancy or the life estate. It's very rare that you see, like my example, X, somebody else conveying for somebody else to use for their life, and then reverting back to the original transfer. The common one is the elderly couple who wants to stay living in their house for the rest of their life, but they want it to go to their children. They do a to Mr. and Mrs. Me for life, then and then they name their children. You have to name your children. Don't say my children. It has to name all of the children. And then when the last of the spouses die, then the property reverts to the remainder men, as they call them. But while they are occupying it as life tenants, they can occupy it under all of the rights that they have as if they had it in fee simple. I cannot tell you how many people I have to talk to and I represent that they do these life tenancies to their children, and then there's one children who comes in and tries to evict them. Like, no, that's not how that works, because they have no future, they have no possession or current use, and the life tenant gets to remain there and use it in fee simple as if they owned it for the rest of their life. So I hope that is clear. If you have any questions, shoot me an email. So then we have non-possessory interests in property. And this is also another topic the book goes into a little bit more. They talk about dominant and subservient easements. I'm not going to go there. The CPA exam does not go there. It's kind of a old school rule. It's not particularly used in the modern real estate practice. But I'm going to break down the common ones that are used and give you general background information here. So a non-possessory interest, this is some interest in land, but it does not include any rights to possess the property. Okay, you have interest in it, but you don't get to possess it. And we have easements, we have something called profits, and we have something called license. And I will say we use the term profits and easements kind of interchangeably now in the real world. We just call them easements. But an easement is a right to enter another's land and use it in a limited way. That's it. They can only use it. They can't sell it. They have no greater rights. But it is irrevocable once you get one, and it has to be in writing, and it has to be what we say recorded. I'll talk about recorded when we do when we transfer real property in the next in a little bit here. So, for example, an easement could be utility companies. They have easements to run telephone poles over a portion of lands. That's a grant. It's in deeds. It's probably in everybody's deed who lives in the city of Plattsburgh. Another easement could be granted an easement, another way of rephrasing it, a right-of-way, or the ability to drive over a certain segment of B's land. A gets a grant of an easement to do that, and all A can do is drive or walk over that portion of land, has access to use that one way or another. He can't go in there and dig it up. He can't give it to somebody else. He can only use it. A profit is very similar, and that's why we use it interchangeably. But a profit is a right to enter another's land and remove items for profit, such as trees, gravel, sand, grass, minerals. It's created the same way as an easement by express in a grant and a deed. It needs to be in writing. Anything involving real estate under statute of frauds has to be in writing. And it's irrevocable. But I also want to note that neither of these two things limit the one who's doing the granting. Just because I grant you an easement to use this land in a limited way does not mean that I can't use that land. It's my land. I'm just giving you the right to use it. Same thing with the profit. I'm giving you this grant to enter and remove trees from my property for profit, but that doesn't mean I can't remove trees from my own property for profit. So, but they're both irrevocable. And I do want to note with regards to easements, easements can be created by necessity, where it's awarded, whether you refuse to give somebody an easement or not. But the common example of that is Al owns a piece of land and it blocks Bert's access to a public road. Bert has the right to use Al's land for access to the public road. That's easement by necessity. And if B or Bert blocks that off, then Al is free to take legal action with regards to getting access to that lot. And that unfortunately happens up here a lot in the Adirondacks. And sometimes state police will get involved, especially if it's obvious of what's going on. There was an issue recently with regards to a road that was whether it was deemed public or private, and this couple from New Jersey who had a camp up here said it was their road and no one else could use it, but nobody else could access where their camps were. It was a big to-do. I still think it's in court, but at the minimum, the court has granted them these other landowners the ability to use it until it's sorted out in court. So anyway, these things do arise. I cannot believe how they arise. They're very common in the Adirondacks. Knowing the boundary lines outside of the city of Plattsburgh can be really interesting, and surveyors come out often, especially when big pieces of the Adirondacks are being sold in smaller chunks. So then the next thing we have is a license. And this kind of distinguishes between the other two. The license is a privilege to enter another's land. So what do I mean by that? It can be revoked at any time. So if you get a license to enter somebody's land, I give you the right to come and hunt on my property. Doesn't necessarily have to be in writing, but I can tell you, yeah, you're done. You can do it this one time, you can't do it the next time. Carl buys a ticket to attend a movie at a local theater. When he tries to enter the theater, Glenn, the manager, refuses to admit Carl because he's not wearing any shoes. Carl argues that he has a ticket, which guarantees him the same right as an owner to come in onto the property. Glenn explains that a ticket is a right that he, as a representative of the owner, can take back. So my question is, who is right? Glenn would be right? You get a movie ticket. Your movie ticket is considered a license. I'm granting you permission to come and watch a movie. Here's your license. I'm not conveying any interest in my property to you, i.e. the movie theater. So I have the right to tell you how you can come onto my property with or without shoes, right? So the ticket holder has a right it does not have a right to force his way into the theater if the rule is you have to have shoes on your feet. Same thing with any store. No shirt, no shoes. It's not the Kenny Chesney song. No shoes, no shirt, no problem. Could be a problem. All right, so back to Rosa and Sam. They're neighbors living in a rural Northern California. Does Rosa have any rights here? Can Sam keep doing what he's doing? And if you were kind of following along, you probably went, nope, Sam can't do what he has continued to do because he is interrupting Rosa's ability to enjoy and use her land in any way. He's interfering with her operation. So Rosa's action is called a nuisance. It's a tort law. And this is an action where If a defendant is causing a substantial and unreasonable interference with a claimant's land or the use or enjoyment of the land, they bring this kind of action. And when you bring this kind of action, what are you looking for? I hope you're saying to stop what's happening next door with Sam's thing, with Sam's operation. And that would be, I'm going to dig right back to the beginning of the semester. They'd be looking for equity relief, which means money isn't going to solve Rose's problem here. What's going to solve Rose's problem here is Sam stopping what he's doing. So a judge can order a injunction to stop the operation of Sam, or Sam may have to take different action. He could still run his business, but he's going to have to do something that doesn't interfere with Rose's use of the property. Now let's transfer real property. So our forms of ownership when you transfer real property: if you are owning property as one individual or entity, because a corporation and partnership can own property too, you own that. Severalty is the fancy word for it. I don't think I've ever used that word outside of law school or the bar exam or right now. We just don't particularly use it, but that's how you would use it. When you have more than one owner, how the property's owned is a little different. And we've touched on these concepts already, especially with personal property, but we talked about it when we talked about risk of loss. And this is when we have concurrent interests. So 2 or more people as co-tenants. They have, it doesn't necessarily need to be people either. 2 or more persons as co-tenants have undivided interests and concurrent possessory rights in the real property or personal property. And each has a non-exclusive right to possess the whole property. So if we have a father who writes in a deed, I retain my property as a life tenant, with the remainder to my 2 children, Sam and Doug. What does the father have here? What type of interest? It's a life interest. No longer has it in fee. And Sam and Doug have a future interest. So this example, father dies and the property will go to Sam and Doug as owning a concurrent interest. So what can they do with this? How do they own it? Well, they own it as undivided interests that are concurrent. They have concurrent rights, and they both have non-exclusive right to possess the whole. So technically they both can live there, and they both can use it at the same time. There is no white line down the middle. You get that side, I get that side. But how they own it is going to be defined in our next couple terms here. So we'll circle back to this example. So we have joint tenancies. And these are folks who have a current interest with all, what we call, with all rights of ownership going to the surviving joint tenant. So they have rights of survivorship, meaning you have all those concurrent interests we discussed above, except if one of those joint tenants dies, then that deceased individual's rights to the property go to the other owners. But you must have these 4 things in place in order for this to be created, a joint tenancy to be created. Time. So the interests of the tenants must begin at the same time. They must have acquired their title in the same conveyance, i.e. a will or a deed. And they must have the same interest in the property, meaning one wasn't conveyed a life estate and the other one a remainder, or a fee defeasible, fee simple defeasible. They have to have the same interest. And the possession has to be an equal right to possess the property. Now, I say all that, this is in the book, lined like this, but the modern view and how we do things today is very different. So for example, I own property by myself. Do I have a slide here? I do. So a woman owns property by herself. And she gets married and wants to have her husband and her to own the property as joint tenancy. Why might she want to do that? Because she might want the property to go to her husband when she dies. Can she do that? Well, if we look at the 4 unities that you need to create a joint tenancy, time, title, interest, and possession, we don't particularly have that, right? We don't have them beginning at the same time. We don't have them acquiring the conveyance at the same time. So we don't have that in this situation. But modern view is we can create joint tenancies. And we do that by having a deed where the woman would deed her property from her. So let's say it's me. Let's say from Rebecca Fox to Rebecca Fox and husband's name, whoever the husband is, as joint tenants. And that's how we would create a joint tenancy. And we can do that with anybody. We could just be 2 folks. If you want to own property and your intent is to have the other person acquire the rights upon passing, upon dying, you want it to go to the next person, not to the heirs, you create a joint tenancy. So A and B own a piece of property. If A wants B to have it when he dies, and it wasn't acquired under the 4 unities, then the language in the deed has to say that they own it in joint tenancy. That's our modern view. So let's talk about some other examples. So A and B each own a half of Red Acre as joint tenants. I say a half because they each get a whole and there's 2 of them, so it's half. If B dies, what happens to the property? A gets it, right? As a joint tenant. So we have A, B, and C are joint tenants of Green Acre, so they each have a third, right? A sells his interest to D without the consent of B and C. What result? Do we have the unities met? We actually don't have the unities met because now we don't have the time, title, interest, and possession all happening at the same time with D, right? So what happens is the joint tenancy terminates or lapses with respect to that share. So D is not a joint tenancy with B and C. So what does that mean? If D dies, he's going to become what's called a tenant in common, and I'll say that right now because we've talked about tenant in common. He becomes a tenant in common. So when D dies, it would go to his heirs. But if B and C die, B or C die, their joint tenancy remains. Their property will go to each other upon their deaths. Another example: if A and B owned the land as joint tenants, A sells to D without B's permission. The joint tenancy is destroyed. So each share will pass as tenants in common. So A and B, and there was my example with A and B owns land as a joint tenant. A sells his interest to D without B's permission. Our joint tenancy is destroyed. D and B become tenants in common. A and B own property as joint tenants. A makes out a will that upon his death, C gets A's interest in property. Does that destroy the unity? No, it doesn't, because B as a joint tenant would own the property upon A's death, thereby leaving nothing for C to take. So that's how the joint tenancy works. You can create them after the fact by adding the words, we own this as joint tenants. You can also add with the right of survivorship. That will even secure it even more if you want the land to pass to the owners of the property. Otherwise, you're a tenant in common. And that's a concurrent interest with no right of survivorship. So it's the same definition above as our concurrent interest. The issue is it becomes an undivided, the issue is it's no right of survivorship, meaning people who have property in common, they own it in common. You got 4 people, 25% each, and one of them dies. That 25% interest is going to go to the heirs of the person who died. So you don't own a specific portion. Like I said, there is no like taping lines. You got this part and you live on this side of the house. They all own it as undivided share of the whole. And each is entitled to occupy the whole. And the only unity here is possession. And as a tenant in common, you are free to sell your portion, lease your portion, mortgage that undivided interest. The question is, will somebody do that? But tenants in common is how people invest in property with each other. If you want to, have a rental place, and you buy it and you want to use it as a business, investment property, that's how people own it. Back to my example with the father who dies, leaving his property to his 2 sons, Sam and Doug. While you might think, well, that fits all the joint tenancies, right? They had their interests begin at the same time. They're acquiring their title in the same conveyance. They have the same interest to own it, and they have the equal right to possess. But under modern rules, unless the language that the father wrote in his deed says to own as joint tenants, it's automatically going to be a tenants in common. So Sam and Doug own that property as tenants in common. So modern law is, if you want a joint tenancy, it's got to say it. And if it doesn't, the deed has to say it. The conveyance has to say it. And if it doesn't, then you're a tenant in common. And on a side note, before I get to tenants by the entirety, in actions where there is disputes among tenants, especially tenants in common, there is certainly judicial recourse. You go to court and ask for the action is called a partition. You file partition action and you ask the court to sever the property. So if the property is not big enough to be chopped up in like equal acreage, then the court will order it sold and the money split after expenses. So that's the legal action any of the tenants can take if there's any sort of dispute. And there's sometimes, there's camps up here in the Adirondacks, and people who pass away leave the camps to the kids, and the kids are all over the country, and only one kid wants to keep it, and you'd have to buy the others out, or sometimes fights happen, and who's going to pay for what upkeep. So a lot of these are pretty common actions up here. So tenants by the entirety. These are strictly between husbands and wives only. The gist is that neither one of them can burden the property without the consent of the other. This is actually an old law. It's kind of outdated. It was created to protect women from being tossed out of homes as a result of their husbands' actions. Because way back when, women couldn't enter into contracts for debt, loaning money. And husbands did that. And when the husbands passed away, those creditors would come looking for their debt in the form of taking the home or the land where the widow now lived. So this is tenants by the entirety put a halt to that, meaning that creditors could not come in and take the property away from the wives as a result of their husband's actions. And while some states recognize this tenants by the entirety, property owned by husbands and wives, some states recognize that this applies to both personal property and real property. In New York State, they only recognize this for real property. So the gist is, if they're going to transfer the property, you have to have consent of both. Each spouse has a right of survivorship, meaning One dies, property goes to the other. And like I said, creditors of one spouse cannot place a lien or satisfy a judgment against property held in this manner. The creditor must be the creditor of both of them. And on a side note, if you're husband and wife and you own property together, but then you get divorced, if you're still owning property together, you become tenants in common. It's automatic. Become tenants in common. All right. So let's sell the property. Contracts for the sale of land. Ownership of real property, they can pass from one person to another in a number of ways, right? You can give it away. There might be a will, some sort of inheritance, but commonly ownership interest in land is transferred by selling it. And my first question is, do you need a contract? Yes, you do. And it has to be in writing, satisfy the statute of frauds. Terms, what you need for terms? Well, the land, right? What are you selling? The properties, the price, signatures. The instrument that we use to transfer property is called a deed, and we have two types of deeds. We have a warranty deed, we have a quitclaim deed. And the difference between the two, we'll just jump right in. The warranty deed, the most common one. Seller makes certain warranties. They warrant, or they're providing some sort of degrees of protection against any defects in the title. So when a seller passes a warranty deed, they are providing the greatest amount of protection for the buyer. So what are defects in a title? What if you don't own it? Or what if there are unknown liens or encumbrances? What if there's errors? What if it was done by fraud? There's not what we call a clear chain of title. And I'll explain chain of title in a second. So what the seller is saying is, I warrant that there's no defects, that I own it, I have the ability to own it. Well, we know we've talked about warranties before. It's the same sort of thing. You're assuring the buyer there's no liens, no creditors are coming to take the property. You're saying that you have title, you have the right to convey it, that it's free from any liens or judgments, except those that might be in the deed, because an encumbrance might be an easement. Oh, my neighbor has an easement across the property. That would have to be in the deed. And there's no, you affirm or warrant that, we call it a covenant of quiet enjoyment. And what you're saying is neither me as the seller or grantor, or any other third party has some rightful claim to this property that will come and disturb your possession. So that's what they guarantee. So Olive conveys a warranty deed of Blackacre to Paul, and there is a mortgage still unpaid on Blackacre. Did Olive breach the warranty? She did if she didn't disclose that there was a mortgage on there. And what does she have to do in order to pass that warranty? She has to get rid of the mortgage. She'd have to pay it off. She has to disclose it or get rid of it. Then we have a quitclaim deed. And a quitclaim deed is a deed that is intended to pass title, interest, or claim that the grantor, seller, may have in the premises, but not in professing that such title is valid and not containing any warranties. This obviously is the other end of the spectrum, where it's the least amount of protection against any defects in the title. So basically it just conveys to the grantee whatever interest the grantor had or has. If there's no interest, then the grantee receives no interest. I can write out a quitclaim deed right now saying, if I have any interest in the Brooklyn Bridge, it's all yours. I can create a quitclaim deed and give that to you. Quitclaim deeds are used in tax sales and foreclosures because it's assumed that the bank or the county or the government doesn't particularly have title. This was somebody else's, and they were awarded it in some fashion. So if you buy property at a tax sale, you usually get a quitclaim deed, that they're not warranting that nobody's going to come out of the woodwork with some sort of encumbrance. While they try and clear up those things, it's not a guarantee. Also, you see quitclaim deeds used with divorce cases or with transfers among family members. Husband and wife separates, but one of them keeps the property, and let's say the property's in both of their names. The person not keeping the property will just issue a quitclaim granting the other person full title. So with transferring a life estate, elderly parents retain a life estate in their property and grant a remainder of future interest to their children. They do that. It has to be done by a deed, and the type of deed they would use is a quitclaim deed. So recording. All states have recording statutes. What does recording the deed, what does it mean to record? You have to record the deed in a county public type of record where the property is located. That's recording the deed. You bring your deed down, your original deed down, to the county office where the property is located, and the term is file it. You hand it over to the clerk. Nowadays, they scan it through, and they put it in their electronic records. They may keep a hard copy, but you actually get the original back after they keep the copy. So what does recording this do? It puts everyone on notice that you are the owner. Right? Puts everyone on notice of grantees' ownership. You have to do this. This must be done if you want to keep your property. If you don't, then the title is awarded to the first one who has complied with the recording statutes. So if I'm selling my property and I give you a quitclaim deed because I don't want to warrant anything, and I do it for a cheap enough price that you're okay with that, and I give you a quitclaim deed, but the next day I give somebody else a quitclaim deed, the first one of you guys to record is going to be the owner of that land. So this recording certainly prevents fraud, because I just gave you an example of fraud. What it also does, though, is it creates a chain of title. Creates a chain of title. What do I mean by chain of title? Everybody who has recorded a deed relative to that piece of property, it could be a transfer because of a sale. It could be because I gave somebody an easement. It could be because I took out the mineral rights and gave somebody access to the subsurface rights, or they bought them in fee simple from me. Anything that has happened with this particular property has to be recorded. And over time, it creates something called a chain of title. I told you a little while back that I don't own it anymore, a very large piece of property for the last 14 years in the Adirondack Park. And when the mineral rights issue came up, I spent a lot of time and a lot of money chasing my chain of title. And I went all the way back to the 1800s and to find and look at exactly how this came out, because it was part of a bigger piece, and then it gets recorded down. Every split from a piece gets recorded down. It gets recorded, and it takes a different, it gets like a sub number to it. So it was quite a large document in the end when I was done. When you sell property, though, in modern society, when we're selling property every day, there's real estate transactions going on. What will be done is something called an abstract, where the seller and the buyer's attorney will hire somebody who does these chain of title checks. But by law, you only have to go back 40 years. So when I bought my property, that mineral right extraction issue did not appear in the 40 years, because it happened back in the 1800s. Somewhere along the line, it just got eliminated out of the deed, and that happens too, i.e. creating a defect in my title. So when I handed off a warranty title, claiming that there's no defects, I had to disclose this ridiculous letter that I had gotten with regards to I own the mineral rights in your property. Never really went anywhere, but nonetheless, it caused me some issues. So recording is extremely important. And while we do all of these things in a real estate transaction, like getting an abstract and looking at the chain of title, we do. It happens through the course of the sale, but there's an update that happens 1 hour before closing. 1 hour before closing, there's a quick update to see if there was any judgments, liens, or anything filed, like at the last hour, last minute, before the sale actually happens. And then the deed will be signed and transferred over. And if you close in the morning, if you have a closing in the morning, that deed is usually filed by the afternoon. If you are closing later in the afternoon, then it's recorded first thing in the morning. So, title insurance. You can do all of these protections. You can have your warranty deed, you can do the chain of title, you can do an abstract check. But title insurance is the big assurance, right? Despite any of those other things, the buyers are usually encouraged to buy title insurance, which assures that title is good and it covers any warranties or defects that may happen. So my question is, who does it protect? You would think the buyer. Yes, but usually the buyer is getting a mortgage. So title insurance is required by a mortgage company. Remember, on the secured interest, they don't want their secured interest getting affected. So they require you, in order to give you a mortgage loan, they require you to get title insurance to protect their interests. And then if you want to pay for your own on the side, you could pay a little extra, and then the buyer has their own self-assurance with title insurance. So what must be in the deed? When real property is sold or it's transferred as a gift, title to the property is conveyed by a deed. And the instrument, that is the instrument for conveying real property. You can't do it any other way but by deed. And it must, to be valid, it must contain these things: the buyer, who's the grantee, and the seller, who's the grantor. You need words indicating an intent to convey the property. So things like I hereby bargain, sell, grant, give, convey. And or it might be I convey and warrant, if there's a warranty title, or warranty deed. Or it might say I convey as quitclaim. You have to identify what kind of deed you're transferring, whether it's warranty or quitclaim, and you have to say I am conveying. There's got to be intent, showing words of intent. You have to have a legally sufficient description of the land. The book outlays 4 different ways with regards to how that is satisfied. Nowadays, we just attach the deed. We all have a deed to our property. If we're selling it, you just attach the deed and you say, see attached. Well, they call it Schedule A, which is a description of the deed. But you just attach a copy of it, and that is satisfactory. I will say, if you live and work in the Adirondacks in the real estate world, you will see some pretty unusual descriptions in deeds. It is not uncommon to see things like land markers, like that old tree stump, or around near the drainage ditch, and things like that. A surveyor will use meets and bounds, and it'd be a little bit more formal. And then you need to deliver the deed. The grantor has to sign it. You don't need the grantee's signature. You just need the one who's conveying it, the grantor's signature. And you need to deliver that deed to the grantee. And you can hand it to them, but most of the time it's recorded, and the attorney's doing that. Once it's recorded, it's presumed delivered. If you give it to your attorney, that's called an escrow, and they're required to file it for you. You will always get your original back. There'll be a copy that, while the clerk's office takes the original, they don't keep the original. They will make a copy of it, like I said, and put it in their electronic records, and then put it in a file. Before I jump to adverse possession, I just want to note real quick with regards to other transfers. Like I said, we just talked about sale, we talked about gift. We can also transfer by will or inheritance. By will, if somebody dies and they have a will, the property will transfer who they stated gets it in their will. If you die without a will, the state inheritance laws will designate who the property goes to. So in general, if you're married, you don't have a will, but you and your spouse own property together, it's going to go to your spouse. If you're the last surviving of the spouse and you have children, it'll go to your children. That's how the state inheritance laws go. But if you specify somebody in a will, it will go to who's specified in a will. So there are times when real property can be acquired in other ways without consent. It's like when you acquire the title to real property, you can occupy it. If you occupy it openly without consent of the owner and for a period of time specified by state statute, you can take property free and clear. We call that adverse possession. You may have heard it referred to as the squatter's law. I don't like to call this the squatter's law, and you'll see why in a second. I'm going to go through these, and then I'll tell you why I don't like to call it the squatter's law. So these conditions, they must be met. And you cannot, the key is you cannot be removed. If these conditions are met, you cannot be removed by the original owner, and you get to keep the property. The property will vest in you if you meet all of these requirements. And these are kind of actually hard to do, hard to meet, but this is not an unusual concept in the Adirondacks. I've had several cases where I've been involved with adverse possession. So let's talk about these one by one. First is the statutory period, and it varies from state to state. I think the range is, I've seen it as low as 5 years, I've seen it as high as 25 years. I think that is the range. In New York State, it's 10 years. So it's like a statute of limitations clock and it starts ticking from the date that someone takes possession, okay? And the true owner has to commence some legal action before that clock runs out in order for you to take possession, plus all of the other conditions have to be met. And the legal action is called ejectment, and I'll talk about that in a little bit. Let's go through these elements though. So you need possession. That possession must be actual and exclusive. The possessor must take sole physical occupancy of the property. And it has to be consistent with normal use, okay? So you enter land, you're kind of making use of it, and we keep using land. I'm going to give you some examples where we're dealing with more than land, but it has to be consistent with normal use. You enter land, you make use of it, maybe you have cattle grazing, maybe you're building things on it, maybe you're mowing the lawn, maybe you're improving it, maybe you're cultivating it, but it must be actual and it must be exclusive. But it also must be open, visible, and notorious. So it has to be so conspicuous that the owner can be presumed to know that you're using it. Like, it can't be a secret, like I'm digging underground and I'm living underground. Now, you have to be able to give a reasonable person notice that you are openly and visibly and notoriously using this. So you're occupying a lot of land, it's not yours, and you're building a house on it, maybe you're starting farming, but it has to be obvious, okay? Then your possession must be continuous and peaceful for that time frame. And what do I mean by that? You must not have been interrupted by the occupancy, by the true owners or the courts. Meaning they didn't start an ejectment process and there hasn't been some sort of court order related to that. So my question is, can you ever leave the property? Well, you can't abandon it and then come back and then start your clock. It starts your clock over. You can't do there's no continuous. So if you abandon and you leave for a couple years and then you come back, your clock resets. So if you abandon it, no can do. What if the original possessor dies? Well, his or her heirs can still bring an action against you, but that doesn't start the clock over either. So if the original owner is still alive within the 10-year period, let's say at 8 years, and their heirs take over, they still have 2 years to kind of get somebody off the property, okay? What if you, the possessor, dies? That possessor's heirs can continue to use the property, and that does not start your clock over either, okay? And then you need possession must be hostile and adverse. So the possessor must claim the property against the whole world. So you can't be living there with the permission of the owner, basically. So there's a few things about this hostile and adverse that's key, and this is why I don't like calling this the squatter law. You can't be living there with permission of the owner, okay? And this possession, this type of possession doesn't occur because you had possession as a co-tenant. So you and I own property, and then I decide I want to go live in Asia, right? That is not going to be hostile and adverse because you stay there and work the property. You can't take it from a co-tenant. And you can't have acknowledged somebody else owns the property. So that's the problem that I have with calling the squatter's law. Because the squatter seems to suggest that, yeah, I don't own this property, somebody else does, but I'm going to take it. Like, that's not how that's not how this particular statute works. A squatter, in my view, is that, let's say you're in a landlord-tenant relationship and your lease runs out and you stop paying rent, and now you're occupying this space. You don't have permission to be there anymore because the lease ran out, and you stopped paying rent, and you stay. And now the landlord has to take action to get you out. That's a squatter. And I think that makes sense explained that way, but unfortunately the squatter's law is kind of used interchangeably with adverse possession versus that kind of relationship, because in the end, the point is you can't have acknowledged somebody else's ownership to the property. So let's look at this example. So Kate and Leo own adjacent property, commercial buildings, in which they operate different businesses. Kate's Culinary Arts, it's a cooking school, and Leo's Coast to Coast Shipping, it's a truck and transport dispatch service. Kate believes that she owns the parking lot behind the buildings. For more than 30 years, she has paid the taxes on the lot, posted signs claiming its exclusive use for her students, and towed away vehicles that did not belong to those students. Leo always believed he owned the lot. However, claims he has never expressly consented to Kate's use of the parking lot, and finally Leo challenges Kate's possession of the parking lot. So the question is, do these fit the adverse possession requirements? We can use any statutory period, but let's say that we are in New York. 10 years, right? So we got that. Is it actual and exclusive? Yes. She's paying the taxes. She's got signs posted. She's towing away vehicles. And I would probably put that in the category of open and visible as well, the same sort of factual pattern. Is she continuing to do it? It says for more than 30 years she's done all of these things. It doesn't sound like there's any sort of abandonment there. Is it peaceful? Well, nobody's trying to get her off. Nobody has brought any action. Hostile and adverse, meaning does she have permission to be there initially? Is she claiming it against the whole world? She sure is. She's showing it out there. She didn't have any consent to begin with, and she believes that she didn't need consent. She's also not holding herself out as taking something from somebody else. She believes it's hers. This is how adverse possession works. In this case, Kate would probably acquire this property by adverse possession. Some examples that I've been involved in involve pieces of property. One was, let's say we have a square lot, and there's 4 pins in each corner of the square lot, but about a foot of the way in, that divides like the neighbor's line, and we'll say my neighbor's line is a row of trees, okay? But there's a foot, that tree line is a foot inside my property. So there's like a foot of grass, maybe 10 feet long. Let's call it 10 feet long. And the neighbor starts to mow that strip because the neighbor thinks that strip of land, well, the tree line must be the property line. That happens all the time. The tree line must be the property line, and it's not. But if your neighbor is like planting flowers and cutting grass along that line for the next 20 odd years, that property owner, that neighbor, could very well take that piece of the property by adverse possession, because everyone believes maybe the property line is here. Maybe the original owner knows that the property line is beyond the tree line but doesn't do anything about it. So those things are very common in the Adirondacks. Little pieces of land like that get taken over or used by a neighbor. So I digress on adverse possession. One more topic to talk about: eminent domain. And even though you have ownership in fee simple, and you can do whatever you want with your property, the government has an ultimate ownership right in all land. So the government can swoop in and take your property. So the power of the government to take land for public use, that's the key term, public use, from private citizens for just compensation. The U.S. Constitution is what allows the government to do that. It's provided for in the 5th Amendment. That allows the federal government to do that by the incorporation of the 14th Amendment. That allows state and local government to do that. But the concept is the same. They have to have a public use requirement. And if they do, and they can show that they do have a public use requirement, then a court will order it sold at what the court deems just compensation. And this concept of the government coming in and retrieving the land is called a taking. A couple examples. If you're building a highway, government determines what it needs for land, and they start a proceeding. It's called condemnation proceeding, where they ask for title, and if they've proven that it's for a adequate public use, the court will give them title, and then there'll be a proceeding to determine the fair value of the land or the market value. Another type of example that we see this come up, if there's a private company that wants to run, let's say, a natural gas pipeline across property of more than 200 landowners in a specific county. Some property owners consent to the use with an offer of compensation. Others do not. So the private company can go to the government, make their pitch that this is for a public use, and if the government feels that, yeah, this is a public use, then the government can start the condemnation proceeding, and there could be a determination. This is, again, common. Just last year in Lake Placid, the town of Lake Placid, village of Lake Placid, wanted to take a vacant lot of land that was owned by the Adirondack Museum Association. They had bought, the Museum Association had bought the land from the neighboring church for like over $1 million. They were going to build a satellite museum, and then the funding kind of fell through for that. So for 11 years, it's it's just been a lot of land in the middle of Main Street, Lake Placid. And the village decided, we want that land. We want to make a bigger parking lot. And the board, passed a law passed a ruling that it was a public use, and that they can just take that land from the museum. And the museum went to court over it, and they won. The museum won. The village of Lake Placid could not show how building the parking spot that they wanted was going to be of public use and add value to the environmental area of what they wanted to do. And basically this was just the government trying to bully a nonprofit organization because they didn't have any business doing that. But nonetheless, it happens, and it happens a lot. So that's it. That's real property, and that's the last lecture of the course.